Hello. Last month, I created the video that talked about the here versus the hereafter. And as promised, that video was more about the here. So today I'm going to go into some more detail about the hereafter, wills and trusts and probate. So we're all generally familiar with those words and somewhat what they mean. I did want to go into detail today, of course, and maybe even dispel some of the misconceptions that I see and talk to folks about. First and foremost, probate, of course, not anybody has a great opinion about probate. I have not come across the person yet who says, oh, I just hoped that I really can go through the probate process or put my loved ones through the probate process, or I had to go through the probate process for a loved one, and it was just fantastic. I had so much fun, right? Not anything that we have ever really heard. So probate avoidance is certainly something that is universally shared opinion by folks. So how do we do that? Well, the first item that comes up is the will. So I've heard many times over the years, well, I have a will, so I'm all set. And unfortunately, that's one of the main misconceptions that I come across. Unfortunately, when you think about a will, you also inadvertently do end up forcing the estate to go through probate. And again, that might not seem like the way that it should happen because, of course, in our society, wills are probably the most popular document that we come across for estate planning. But if you think about what a will actually is, it is certainly placing your wishes, down on paper, document, right? But then, what is the process for utilizing that will? Well, probate is the process. So the will is a guideline for the probate process itself, but again, forces the estate to actually go through probate so that the probate judge can read through it and then pretty much put their seal of approval on what is then to happen with the proceeds of the estate. So if you think about what probate actually is meant to do, probate is meant to pass the assets from the deceased owner to the next in line. And the will is the guideline or the document that is prepared to do that. But the will itself does not carry enough legal weight on its own, meaning you could not take a will, and I'll use us as an example. If someone walked through our door with a death certificate for someone and a will, unfortunately, that would not be enough for us to transfer then those assets to the next in line. Unfortunately, again, that is one of the main misconceptions. So when you do think about a will, you do then have to think about probate. So obviously, with us wanting to avoid probate, a will is not necessarily the best tool in our toolbox to be able to do that. Well, what about a trust? Well, a trust certainly is a legal document that you prepare, but on its own, again, a trust does not actually magically, I guess, get your assets from your ownership to then the next in line. So if you have an account that is owned in your name alone, but then you also do have a trust document, that would not automatically push those assets to whoever you've named as the beneficiary in your trust. The trust actually has to be funded. And we see this from time to time as well, where folks will have a trust prepared, but then not effectuate the trust or place the assets into the trust, bank accounts, investment accounts, property, those kinds of things. And then inadvertently, those assets go through probate. So the probate process, again, is meant to just transfer those assets that have not already been taken care of through proper titling, through a beneficiary designation, or through the ownership of a trust. So do you have to have a trust then in order to avoid probate? The answer is no. You can avoid probate through having the proper titling. So if you think about joint ownership, you and a spouse typically would own a joint bank account or certainly your home. So when one passes away, there still is a living owner, and there is no need to go through probate in order to transfer that property to the remaining owner. However, that does sometimes create an issue where, well, now you only have one owner of that particular asset, and so when that owner passes away, the risk of probate is certainly there. So we can add a beneficiary designation, as we encourage everybody to do on their retirement accounts and other investment accounts. Properties are a little bit different. You can, through what's called a ladybird deed, have probate avoidance for your homestead. And a trust is just another way. So with regards to a trust is nice in that it kind of elevates what you're trying to do in a will, which is lay all of your wishes, out, the who, what, where, when, and how assets and property get transferred. So if you name the trust as your beneficiary, if you have the trust own investment accounts or properties, then by default, those assets are no longer owned by you. Even though you are the owner of your trust and you control it and you are the beneficiary of it, so you and the trust are one and the same while you are still here. So in the hereafter, there isn't the need to transfer ownership, and there certainly is not the need for probate to get involved, because you've already laid out your wishes and you have properly titled or listed the beneficiaries properly, so that probate does not have to get involved. And this really elevates the transfer of property through contract law. And so contract law is kind of the lay of the land. It does supersede really anything that would be even written in a will. So you could, as an example, have something written in your will and something completely different written in your trust. And if the trust is the owner or the beneficiary of the property, the trust is what will rule the day. So again, we're here to try to dispel some of these rumors that may be out there. Now, does everybody need a trust? No, I wouldn't say that everybody needs a trust, but a trust is a nice thing to have. Estate planning, a lot of times, is another form of insurance. It's voluntary. I'd rather have it and not need it than need it not have it, kind of a thing, like life insurance and some other various insurances as well. So we do encourage people to at least think about it, have the conversation. If you even want to go down the path of engaging with an estate planning attorney, in that, that's who would prepare these documents for you, all of them, wills and trusts and powers of attorney as well. And you generally will still get a will. And it's a just in case document, just in case something didn't get titled correctly or didn't get funded in the trust and unfortunately does have to go through probate. Then you do want a will to be able to make sure that your wishes are honored. But again, ideally, you're going to have everything transfer to the next of kin without having to go through that probate process, because the things we all generally know about probate is that it takes a long time, and it has a cost associated with it as well. So less than ideal. Trusts have another advantage, particularly for those who have minor children. And this is another one of those topics that really is not discussed all that well. So anybody out there listening to this who have minor children or minor grandchildren, listen up. This pertains to you. And unfortunately, if something were to happen to the legal guardians of those minor children, those assets, of course, then go through probate, and friend of the court certainly gets involved, and it's messy, to say the least. The last time I checked, nobody wants the government getting involved in their affairs, especially with when it comes to the management of their children's assets. So the will actually will name the legal guardian of the minor children. If then friend of the court has to get involved, those assets are held on behalf of the child. And then at 18, when they're legally an adult, all of the assets then are distributed to them. I have not had anybody tell me so far that, yep, that's the plan, right? If something unfortunate happens to the parents, that they really want the state involved, and they really want their children then to get everything the day that they turn 18. So again, a trust can be very useful in a situation like that. Hopefully never is needed, of course, but those assets then can transfer into the trust and be managed by whomever you choose as your successor trustee after you. And at 18, nothing really has to happen. You can hold those assets in trust for the children for any length of time, and distributions can be made for any reason. A lot of times we see kind of a two-pronged approach inside of a trust for situations like this. Either the children make the right decisions and the distributions occur, or maybe they're not on the straight and narrow path, and a different distribution cycle might end up occurring. So again, a little bit of a misconception there. Not great and fun topics to talk about, of course, but important nonetheless. So for now, I think I'll stop, but there's more that we can certainly discuss. If you're curious about this, you want to have a more in-depth conversation, I'm always willing. I do have referrals to estate planning attorneys if you want to potentially go down that path. And I hope you found this video informative as far as the hereafter is concerned. Thank you very much for listening.